Hey guys, it's Lola here and welcome back to my channel, or welcome if it's your very first time watching a video of mine. On this channel, I create content around all aspects of growing up and gaining adult independence, including content around money, property, careers, and general well-being. Before we get started, please do click subscribe and do hit that bell so you don't miss any videos from me. If you've been watching my channel for some time, you'll probably know that I work in HR and sometimes I like to cover HR topics. Today is one of those days and I'll be speaking about disciplinaries. Everything to do with disciplinaries, including what to do if you find yourself in a disciplinary procedure, what your rights are and what you should do. So if you find yourself in this position or you're just keen to SWOT up for the future and know your rights, stick around. So, first things first, what is a disciplinary procedure? You probably hear the word disciplinary thrown around when people get in trouble at work, and that's essentially what it is. Your employer is allowed to govern how you behave when you're employed by them within reason, and if you break these rules, then you can get into trouble and you can be disciplined. So, examples of those things may be stuff that's written in your contract or in specific policy. So, something like your working hours, that's written in your contract. That tells you when you're supposed to get to work. If you continuously don't do that, then obviously you can get into trouble. Other things are written in specific policies, like a social media policy, which dictates how you're supposed to behave on social media as it pertains to your job or your employer brand. So if you go online and racially abuse somebody, for instance, and then your employer finds out, then that again is something that you could get in trouble for. We've seen it a lot in the media and stuff like that. Other things are just based on common sense or law. So for instance, don't assault your colleagues. If you did that, you would get into trouble. When you get into trouble, your employer is allowed to discipline you. So that means that they can impose a number of different sanctions. So if it's maybe not as severe, you might get like a verbal warning or a written warning. And then for the most serious of cases, you could essentially end up being dismissed or fired. There are some other kind of sanctions that they may put in place, such as, demoting you. So if you were like a manager and you did something, they may say, do you know what, you've proven that you're not able to manage people and, you're not trustworthy enough. So, we might temporarily demote you or something like that. So what should you do if you find yourself in a disciplinary process? You want to know what to do, you want to know what the process is, you want to know what your rights are. One of the first things to know is that disciplinaries are kind of like court cases. So it's not a case of guilty straight away. It's really innocent until proven guilty. If someone makes an allegation against you, you should have the opportunity to defend yourself, to listen to the claim that has been made against you, to review the evidence, to present your own evidence, and to essentially defend yourself. And it's really important to do that. The main exception I would say to that is during your probation period. There's usually a clause in your contract which says during your probation period, the disciplinary process won't apply. And that essentially means if you do something, you can be out without anybody really looking into it any more deeply. A responsible employer will follow the process. The process will either be set out in the disciplinary policy that your employer has internally, and if they don't, you can kind of refer to the ACAS Code of Practice, which I'll link below, but most employers will have a disciplinary policy. If your employer doesn't follow the disciplinary policy and you are subsequently dismissed, then you could make a claim for wrongful dismissal if you've been with them for more than 2 years. But most employers will just follow a disciplinary procedure because it's what they're supposed to do. In terms of the process, a disciplinary procedure usually starts with an event. That is something that happened, that someone is alleging broke some sort of rule or whatever. At that point, it'll be going to HR or line manager or whoever in your organization is responsible for employee relations or human resources. Any sensible HR person is going to tell you if it's not a big issue, deal with it informally. That's not because we're work shy or anything. It's because disciplinary processes are usually really horrible to go through. For the individual involved, if you go through a disciplinary, it's not nice. Line managers hate doing it. HR hate doing it. It's not fun. It's not a nice thing to go through. So if it can be dealt with informally, that's what we would typically advise. So for instance, one line manager has someone in their team, Karen. She keeps showing up to work late. It's been 3 or 4 times now she's shown up to work late over the period of 2 or 3 weeks. We're not going to say put Karen in a disciplinary. We're going to say speak to Karen and tell Karen to come to work on time. Karen should already know this, but a reminder is not going to hurt anybody. So line manager pulls Karen to a side and says, hey Karen, you showed up to work late a couple times now. It's having this effect that you need to show up to work on time. From then on, if Karen has any sense, she's going to come to work on time. Or if there's a reason that Karen can't come to work on time, something that's stopping her, that would be her opportunity to share with her line manager. So maybe she starts coming to work on time, or her line manager understands that there's something. So maybe actually, rather than Karen starting at 9, she could start at 9:30 and finish half an hour later than everyone else because she has like a childcare issue that consistently pops up or something like that. That is good HR work. Disciplinary should not be like a first port of call or anything. And employers that use disciplinaries for really minor issues are just kind of rubbish. So we try to avoid doing stuff like that. If something has been dealt with informally already and it hasn't worked, so if Karen then decides that she wants to keep coming to work late and there is no real reason for it, then it would escalate into a formal disciplinary process. Or if the event that happened in the first place is not, it wouldn't be appropriate to try and deal with that informally. So if one employee like assaulted another employee, or if an employee stole or something like that, that's just going to go straight to a formal disciplinary process. At that point, you'll be told. If you're the person, the subject of the disciplinary process, you'll be told that an allegation has been made, that you've broken some rule, or that there's been some misconduct. This is what it is. You should be given specifics. So you should be told stuff like what the allegation is. You can't just be told you're in trouble, come to a disciplinary meeting. You should be told what they've alleged that you've done, so that you've stolen something, the policy that you've broken our disciplinary policy because you've breached trust and confidence or whatever. You should be told when what the next steps are, what the possible outcomes are. So they'll say, this could result in a first warning, a final warning, or even dismissal. All of that stuff should be given to you in writing. If your employer does not give it to you in writing, you should ask for it in writing, because when someone gives you something verbally, especially something this serious, which could result ultimately in the loss of your job, it's really hard to reflect on it later, and it doesn't give you the information you need to go and start preparing your case. Once you've been told about the allegation, the next step is the investigation. And that is pretty much what it sounds like. Someone will go and do an investigation, someone independent, so not someone who's already involved. Probably someone in the HR team will go and speak to the people involved, understand what the allegation is, see if there's any evidence, and they will basically form an opinion about whether there is a case to hear. So if they go and do the investigation and find out, to be honest, it's kind of baseless, it's really petty, and actually it doesn't need a disciplinary process because it's just not worth it, they will just discard it. And then they will write to you to say, we've done an investigation and actually nothing is going to come of it because of blah, blah, blah. Go about your life. If the case does move forward to a disciplinary hearing, then you'll be provided with all of the details of that again in writing. So the time, the location, you should be provided with any evidence that has been collected during the investigation, blah, 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 blah. It will all be provided to you. In terms of the time and the location, they should be convenient for you. There's no legal minimum amount of time, but case law basically says that anything less than 24 hours is probably going to be unfair because it's not going to give you enough time to prepare. However, even if they give you 24 hours and you don't feel that that is enough time to prepare, and in a lot of cases it won't be, if there's like a lot of evidence to go through, if you need time to actively think, if you're really busy at work and you haven't even had time to go through that stuff, it's perfectly acceptable to ask for that to be delayed. You can't delay just for the sake of delaying. It has to be a good reason. So typically there are two really good reasons. One is you want more time to prepare. The other reason is to bring somebody with you. So everybody has the right to be accompanied in a disciplinary situation. There are two people or two types of people that can accompany you to a disciplinary hearing. They're called your companion. The first is a colleague. So anybody else that you work with, you can ask them, hey, I'm going to a disciplinary hearing. Do you mind being my companion? The role of the companion is there just to support you. They may ask questions. They're not there to answer questions on your behalf or to answer the case for you, but they might ask questions. You might want them to take notes for you. And generally they're there to be supportive so that you don't necessarily feel like everybody is against you and you have somebody on your side as well. You can also bring a member of a trade union. So if you're a member of a trade union and you pay your subscriptions every month and you get called into a disciplinary hearing, your trade union will be able to provide you with someone to go to that meeting with you. And your trade union representative will do the same thing that your companion would do. So they might ask questions, they might summarize some stuff, they will generally support you, blah, blah, blah. If your companion, for instance, couldn't make it on the day that they put there, then actually that's a very reasonable reason to ask for your disciplinary meeting to be delayed. There is a reasonable time frame. So if you're asking to delay it by a week, that's probably going to be okay. If you're asking to delay it by 2 or 3 weeks, then actually your employer may see that to be like unreasonable delay and they may say no. So once you have the time, date, location, all of that stuff sorted, you just use your time to prepare. You basically look at the evidence they've provided, see if there's any other evidence that you want to bring, check if the evidence that they've provided is even credible, right? If there's something in it which is like factually incorrect, say it's factually incorrect. If they provide you a policy that you've never seen, say you've never seen it. If there is kind of prior history between you and somebody who has provided a witness statement, say that. Anything which could be which could colour the evidence or make it less fair, then you should be saying that. You should come prepared to say that. It's not the case that you go into the disciplinary hearing and you start, paging through all the evidence that they have. Just, read it in advance and use your time wisely. In some cases, you'll look at the evidence that they've provided and it will be super clear. You did it. You're guilty. They caught you in 4K. There's nothing you can do about it. Doesn't mean you should fall down and die. It means that you should start thinking about what you're going to say in the disciplinary hearing. If there are mitigating circumstances, then you should speak about that. If there are circumstances that led you to behave in a certain way, even if it wasn't the right way, you should say that. So for instance, if you said something to an employee which wasn't particularly nice, you might say, look, I did act out of character. It's not the right thing that I should have done. But actually, there's a long history of this employee being quite abusive to me. Here's some of the texts that they've sent me. Here's some emails that I've gotten. And you can see that it was really a retaliation, for instance. You should also think about how you want to present yourself in the meeting. Again, it is kind of like a court case. So when it comes to sentencing or what punishment you're going to get as a result of the behavior or the misconduct, then actually it helps to show your employer that you acknowledge what you've done and actually it's not going to happen again, what things you've done to make sure that this kind of stuff doesn't happen again, blah, 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 blah. All of that stuff is what you should be doing in the lead up to the meeting. If it's really clear that you have done it and you don't really want to necessarily put up a fight. In terms of the actual meeting, they may be put in the diary for 30 minutes, an hour, or an hour and a half if there's a lot to unpack there. It may be the case that you show up, they say you did this, you say, yeah, I did do it, I'm really sorry, this is why I did it. They say, hey, fine, you move on, you're all done in 15 minutes. Or it could be that there's a really complex thing that happened where there's lots of documents and stuff to go through, lots of stuff that you want to say to defend yourself, lots of evidence that they've collated against you, blah, blah, blah. So that can take a little bit longer. The meeting will typically start with whoever's chairing the meeting introducing themselves. So, hey, I'm blah, blah, blah. If you know them already, fine. And I'm going to be chairing this meeting. This is how the meeting will run. My role here is to listen to the evidence, blah, 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 blah. And at the end, I will be making a decision. Such and such here from HR is going to be making the notes. A copy of the notes will be made available to you if you want them at the end of the meeting. I see that you've brought a companion. Does your companion want to introduce themselves? Okay, this is how the meeting will run. Is that clear with you? If you don't bring a companion, they'll say, I know that you haven't brought a companion. Did you know that you have the right to bring one? You'll say, yes, we'll proceed in any way, blah, blah, blah. All of the formalities happen at the beginning. Then a case will be put forward to you. So they'll say, look, someone has alleged that you've done this. The result of the investigation found X, Y, and Z. It kind of looks like you've done this. What do you say? And that is the point where you will kind of share what you think, any defense that you have for yourself, any of those things that we spoke about before. The outcome of the disciplinary hearing probably won't be provided until later. In HR, we learn it's actually quite bad practice to do a disciplinary meeting and then make a decision at the end of the meeting, because actually sometimes, most times, you need time to consider the evidence that has been presented to you, any defense that the person has had. You want time to, consider it in the round. And if you make a decision at the straight end of the meeting, we're thinking that you actually haven't reflected on this at all. So typically they'll say to you, thanks for your time. It's going to take me a couple of days to be able to get back to you, but I should have an outcome by X time. And then you say, okay, cool. And then at some point in those next couple of days or within 24 hours or whatever time frame they've given you, you would receive an outcome letter. And in that letter, it would tell you, it would summarize what happened in the meeting, what was discussed, maybe what your defense was, and then it would say, as a result, the outcome is this. Sanctions are usually like on a ladder. So in theory, your first offence would be a verbal warning. Your next offence after that would then move you up the ladder to like a first written warning. And then after that, it'd be like a final written warning. And then your next offence after that would be a dismissal. So in theory, you can do quite a few things at work before you are dismissed. However, employers have the right to exercise discretion. So the person chairing your disciplinary hearing has the ability to skip any of these steps. So if you've done something that's fairly minor, they might say actually go for the verbal warning. But also if you've done something serious, they might say, do you know what, we need to jump straight to a final written warning, and if you do anything again, then actually we're going straight to dismissal. Or in the case of like gross misconduct, things that are just like completely unacceptable, then they can jump straight to a dismissal. The outcome of the disciplinary hearing is the outcome. Someone has made a decision, looking at all the evidence, listening to your defense and blah, 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 and this is the decision they've come to. Hopefully it's a fair decision. However, if you're really unhappy with the decision, you can appeal it. You can't just appeal because you're unhappy. There are 3 specific bases on which you can appeal. The first one is that the outcome is too severe. So in the case that we spoke about with Karen, let's say she did end up getting a disciplinary hearing, and then she's been there for a couple of years, she's had a bout of lateness, and then they've dismissed her. She might say, look, I accept that I was late, I shouldn't have been late, and maybe it was a disciplinary offence, but I don't accept that actually I've been late 4 times and now I'm going to be dismissed. So for me, that outcome is not fair because I know other people who have been late and they haven't gone through that same sort of thing. So that's what it means by the outcome being too severe. The second reason is that the process was procedurally unfair, and that means that something in the process didn't happen as it should have. So for instance, maybe you weren't given the right to be accompanied by a companion or someone from a trade union. Maybe you weren't given enough time to prepare. Maybe you weren't told what the allegation was until it happened, and maybe they skipped the hearing completely and you were just told. All of these things you could appeal and say, hey, I don't think a fair process was followed. So that's the second potential reason. The third reason is that now you have new evidence which wasn't considered the first time. So basically, you have some new evidence which you think, if it were to be considered, would change the outcome. So a really extreme example would be maybe you were caught having a fight with a colleague and you said, hey, I was defending myself, but actually when you've been caught, the 2 of you were fighting, you both have bloody noses, you shouldn't have been fighting, and now the outcome that both of you have been given is that you're being dismissed. You may have gone to security and gotten the CCTV and say, hey, I know when we had a disciplinary hearing we didn't have the CCTV, but I've got the CCTV now, and as you can see, Dave attacked me, and actually you can see now I'm defending myself. So now when we've been caught, you can see that both of us are fighting, but actually I had no choice. So maybe I shouldn't have been fighting, and maybe there is a disciplinary sanction, but maybe it's a first written warning rather than a dismissal. So that's what new evidence would be. The person that chairs the appeal hearing should ideally be more senior than the person that did the first disciplinary meeting. And that's because that person has the ability to overturn or uphold or even upgrade the sanction that the first person put in place. And if you can imagine, if someone is more junior, they might be a bit worried about contesting a decision that someone more senior than them has made. So usually the appeal hearing is chaired by a more senior person. They'll do very similar things to what happened in the first meeting. They'll go through all the evidence, including any new evidence that you've submitted, and they'll make a decision. That decision will be one of 3 things. Either they uphold the decision that's been made, so no changes. They downgrade the decision that's been made, so maybe taking it from a final written warning to a first written warning, or they can actually upgrade the decision that's been made. So imagine you were on a final written warning and they say, I actually think you've got off a bit lightly and I think you should actually be dismissed. I think that happens less frequently, but it is still a possibility, so it's something you should consider if you are going to appeal a decision that's been made. At that point, that's it. There's no more appeals. There's nothing you can do internally. It all has to happen externally. So you do have the option of taking your employer to an employment tribunal if let's say you've been dismissed on the back of a disciplinary process that you don't think was fair. But that is essentially suing your employer, and it's a story for a whole different day. And that's pretty much it. That's how a disciplinary procedure works. If you've made it to the end of this video, thank you very much, and I hope you found it helpful. If you have any questions on this video or any other video, of course, drop me a comment and I'll be sure to respond. As always, I appreciate likes, comments, subscribe, share it with your mates or anyone you think may find it helpful, and I will see you next time. Bye.